When you deal with an international probate case that involves a German-speaking country, Germany, Austria, or Switzerland, you will most likely encounter the term Erbschein. The verbatim translation of Erbschein is certificate of inheritance, which is similar but also different to a grant of probate that you are used to in common law countries, because in German-speaking countries, you, in most cases, do not have a personal representative, which means there is no executor or administrator. Instead, the heirs administer the estate directly, and there is no interim person involved. Hiring a German lawyer is a very simple and straightforward process. This is due to the fact that everything that involves the client-lawyer relationship is already laid out in statutory law or professional lawyer regulations. This means in practice that if you want to hire a German lawyer, your lawyer will probably ask you for three things. Number one is a power of attorney. This is due to the fact that the lawyer will have to present this to the probate court in order to obtain access to the probate files. Number two is the fee agreement, which is usually fairly short, usually a one-pager. And number three, a retainer upfront payment. And here, unfortunately, most German lawyers do not accept credit cards, so you will have to make a wire transfer. But other than that, you will have to sign two things and make an upfront payment by wire transfer. The costs of a European lawyer usually depend on the experience of the lawyer himself, the size of the law firm, and the size of the city the law firm is in. In Germany, for example, the range is usually between 150 and 250 for junior lawyers fresh out of law school, up to 800 euros to 1,500 euros for senior partners in big law firms in big cities like Munich, Frankfurt, or Berlin. For Graf & Partners, a highly specialized niche law firm for international probate, our fee range is between 300 and 600 euros. By the way, contingency fees, no-win, no-fee agreements, are prohibited under German law, so this is the reason why German lawyers do not respond if a US client asks them for a no-win, no-fee agreement. Unfortunately, a United States grant of probate is itself not valid in a European country. That means that if the deceased owned property or had any other assets in a European country, you will have to go through the probate process in each of those European countries. There is one exception where the deceased had his habitual residence, which is pretty close to domicile, in a European country. That means if the deceased lived at the time of death in a European country, you can obtain one single probate, which is then valid throughout Europe. But in a standard case where the deceased had lived in the United States, you will, as I said, unfortunately have to go through various probate proceedings in Europe. The main difference in probate proceedings between the United States and the European countries, Germany and the United Kingdom, is that in Europe, there is usually much less direct court involvement in the administration of the estate itself. That means that both in Germany and in the United Kingdom, the probate court usually merely issues the certificate of inheritance in Germany or the grant of probate in England, and then the court doesn't do anything anymore. That means that there is no direct supervision and no direct control of the executors by the court. This aspect is actually one of the most surprising and dangerous differences between the succession laws in common law countries like the United States and some European countries. In some European countries like Germany, for example, or France, you can inherit the debts of the deceased. which means that you will be liable for the debts of the deceased with your own personal wealth. Unless, and this is the important part, unless you actively renounce the inheritance within a certain deadline given by the court. So if you are notified by a German, French, or other European probate court, you must absolutely make sure to react in order to avoid to be liable for debts of the deceased. When you apply for a grant of probate in a European country, you need to convince the court that you are actually the person entitled to the estate. If there is a will, you need to obviously submit that will. In most cases, this will be a certified copy, a legalized copy with an apostille, plus a certified translation. If there is no will, you need to demonstrate to the court that you are the next of kin entitled to the estate under that country's intestacy succession rules. In order to prove this, you will have to submit a number of documents, in most cases marriage certificates, birth certificates, death certificates of your parents, for example. So it depends on the circumstances of the specific case, but in most cases you will have to submit a number of documents which need to be legalized and which need to be translated by an official certified translator acknowledged in that country. If you need to take out a grant of probate in a European country, the process will take anywhere between 6 months and 2 years. That is in uncontested probate matters. The duration very much depends on how quickly you can convince the court about the fact who is entitled to the estate, which is linked to the required documents. So the quicker you can produce the documents in certified and legalized form and with the required translations, the sooner you will obtain the grant of probate. If you have to take out a European grant of probate, it isn't absolutely necessary that you personally travel to that country to deal with the probate formalities. You can instead instruct a local lawyer, or if you have one, another person that you trust. However, it may speed up things tremendously if you travel there at least once for, let's say, 2 or 3 days to deal with the oath, the affidavit, and other formalities with banks and the probate court. The rules of intestacy in European countries differ slightly from country to country. In common law jurisdictions like the United States and also the United Kingdom, the surviving spouse traditionally has the stronger position compared to the children. In civil law jurisdictions like France or Germany, the children have a much stronger position. For example, in Germany, the estate goes 50% to the surviving spouse and 50% to the child or children. So in effect, you will have to check what the statutory rules of intestacy are in the jurisdiction where the deceased had assets in order to find out who has the better position. In order to sell the assets of an estate, you will in most cases first have to obtain the required national grant of probate, because the buyer will have to be sure that you are actually entitled to sell those assets. In certain circumstances, however, you may even be able to already sell your share in the estate. This requires, however, that you can convince the potential buyer that there are no unknown debts and that you are actually the person who would eventually obtain the grant of probate. So the standard approach is that you can only sell the assets in 2 steps. Step number 1 is obtain the grant of probate. Step number 2 is then sell the assets. In In most cases, you will only be able to access assets in European countries after you have obtained the grant of probate. Banks, for example, will not disclose the balances on the bank accounts or any other information unless you can provide the grant of probate. However, in some European countries, Germany, for example, there is the tradition of granting power of attorney to a loved one, to a trusted person, which will then enable you to get this information or even access the bank account, for example, prior to having obtained probate. But this, in international constellations, is usually the exception to the rule. So the rule is obtain the grant of probate first, then access the assets. If there is no will, then in most European countries, the next of kin will automatically inherit the estate. In countries that apply the principle of universal and direct succession, like Germany, for example, there is no need for an executor and a representative. In those countries, the heirs, the next of kin, will then automatically administer the estate. In other countries, like Austria, for example, there is the need for an administrator, and the administrator will be court appointed. In those countries, however, in most cases, also the next of kin will be the natural administrators. Unless there is a dispute about the estate, then the court will appoint a neutral person like a lawyer or a tax advisor. But in all other circumstances, the next of kin will be the administrators. For the probate court, the oath or affidavit is the most important part of the probate application, because in that oath, the applicant swears that all the information contained in the application is correct and complete. Therefore, there are very high requirements under German law, for example, and also English law, where you can take that oath. A normal notary, for example, in the United States is not sufficient. This means that if you do not wish to travel to Europe to make an application, you will either have to go to a local embassy of that country, the German embassy, for example, or the French embassy or Austrian embassy, or in the case of England, you can also appoint a so-called attorney who takes that oath for you. In most European countries, you will only be able to access the assets after the respective tax authority has given you a tax clearance, an inheritance tax clearance, that is. In order to obtain this, you will have to complete certain forms. They can be complicated or simple depending on the circumstances of the case. In England, for example, you will not even obtain the grant of probate before the English tax authority has given the green light for the probate court to do so. In Germany, you will be able to obtain the grant of probate. However, the banks, for example, will not release the assets until you can show to them that you have been granted the tax clearance in addition to the grant of probate. In short, this is a topic that you will need to obtain the advice of a respective national tax advisor for, unless you can speak the language that well that you're able to complete those forms yourself. Most European countries levy estate tax or inheritance tax or death tax, at least on the assets that are located within that country. Some European countries even levy estate tax on the global estate, at least if the deceased had had a residence there. Other countries, like Austria, for example, do not have an inheritance tax or death tax at all. So it very much depends on A, where did the deceased have his or her residence, and B, where were the assets located. If you are notified by a European probate court that a loved one has died and obviously had assets in that European countries, because otherwise you wouldn't be notified by the court, then you should act immediately, especially with regards to countries that apply the principle of universal succession, like Germany, because in those countries you can even inherit debts. But in general, you should, of course, react immediately, and probably, unless you are well-versed in that country's succession laws and speak the language well, should hire a local lawyer to take care of this estate matter for you. According to international treaties, wills are usually recognized mutually between countries, in the Western world at least. This means that United States wills are recognized all over Europe. The more important question, however, is whether that United States will actually says that it also covers the assets in those European countries. Because sometimes United States wills say that the wills only cover the estate in the United States or even in certain states. But if the will is general and covers the estate all over the world, then the terms of the United States will also are valid in Europe. Some European countries, like for example Germany or France, use so-called forced heirship rules. This means that if a person, a very close relative in most cases, has been disinherited in a will, that person is still entitled to a minimum share to the estate. Usually we're talking about spouses, children or grandchildren. So if you have assets in Germany or in France and you don't want the next of kin to inherit anything, you must ensure to know about the so-called forced heirship rules, because under these rules, those close relatives or your spouse may still be entitled to a minimum share of the estate. Whether you are entitled to a share of a foreign estate, first of all, depends on the question whether there is a will in which you are mentioned. If so, then of course you are entitled to the share according to that will. If there isn't a will, then it depends on the intestacy rules of that country. If you are entitled according to those countries' intestacy rules, then you also can apply to a share of the estate. In certain countries, like Germany or France, there is even a so-called forced share rule, which means that if you are disinherited in the will, then you may still be able to apply for a minimum share to the estate. Those forced share rules, however, only apply to very close relatives, spouses, children, grandchildren, most of the cases. So it makes much sense to have this checked out by a local lawyer. If somebody challenges the validity of a will, whether it be a European or a United States will, then the normal probate proceedings turn into an actual litigation case. This means that the probate proceedings will take significantly longer and will be very expensive. So it may be a good idea to talk to that person challenging the will and trying to find out whether that person would be willing to come into some form of settlement. If not, then our firm will be happy to represent you in such contentious litigation probate proceedings, either in Germany, the United Kingdom, or Austria. If you are appointed as an executor in a United States will or in a European will, then you can, and actually you even have to, act as the executor for the European assets as well. This doesn't mean, however, that you cannot appoint a lawyer or another trusted person as your attorney if you don't speak the language, but the executor position will be held by yourself. If you do own foreign assets in a European country, your primary goal should be to avoid that your loved ones have to go through probate proceedings later on. You can achieve this by using various legal tools of European countries. In some countries, you can, for example, use something like a living trust that you're used to from the United States. Other countries provide so-called powers of attorney valid beyond death, which means that the person that you have granted power of attorney is actually able to access bank accounts or to even sell property based on that power of attorney, which means they don't have to go through probate. In short, you should definitely look into this issue and get professional legal advice in the country that you own assets. Many European countries apply the so-called principle of universal and direct succession. This means that there is no need for a personal representative if somebody dies. Instead, the inheritors, be it the next of kin, if there is no will, or be it the persons named in a will, inherit the entire estate directly and immediately, without the need for an executor or administrator. The downside to this concept is, however, that those inheritors can also inherit unlimited debts of the deceased. This means that in those countries that use the principle of universal succession, you should make absolutely sure that the estate isn't over-indebted, because if it is, then it is possible that you inherit more debts than assets.